of the state's witness, Joanna Reyes, where he inquired of certain statements that she made, and the name Rashard, R-A-S-H-A-R-D, Horace, H-O-R-A-C-E, to him, a boyfriend that she lived with for a period of time, I think a 1 month and a half in Houston, and was dating here in San Antonio. In that regard, the witness was supposed to arrive in San Antonio, told our investigator, Joanna Collins, who is in the courtroom, and she has been previously on. She's a licensed investigator, and she's been working on this case with us for over 5 years, I believe. And I would represent to the court as an officer of this court that the witness, Rashard Horace, who had promised or indicated to us that he would be in San Antonio, meet with her at my offices here in San Antonio at 4:30. Late last night, I believe it was after 7 p.m., he contacted Ms. Collins, our investigator, and advised her that he had retained counsel, and that he was not going to testify, that he was going to invoke his Fifth privilege. Based upon that, we were confronted with several issues. One, I believe under the Texas Code of Professional Ethics, rules of professional ethics, I believe it would be improper for us to continue to talk to him once he advised us that he had retained counsel. Secondly, it would be improper for us, I believe the law is clear, to call him as a witness to invoke his Fifth Amendment privilege in front of the jury. I know I would object to that at the state case. Given those facts, we have been unable to reach his counsel, and I've provided the state with, and I would offer to the court what has been marked as Exhibit 12. I would advise the court that Exhibit 11, which has also been tendered to the state, and I believe one of the able counsel has listened to it. Ms. Collins advises that she didn't realize that when they called her office instead of her cell phone, that there was a recording. And so we have a recording of her conversation with him, which is important for purposes just of the record, not before the jury. But I would offer defendants Exhibit 11, which is the recording of the conversation between Joanna Collins, the licensed investigator, and Mr. Horace. And I have tendered it to counsel, and I would offer that solely for purposes of the record.
All right, so if you could label that so there's no confusion, D11R and D12R.
D.
Just add the letter R.
Defense 11R.
Yes.
And defense Exhibit 12R, which I've also tendered to counsel, is the name Richard Horace and his telephone number, which we are not calling because he's represented by counsel, and his attorney, which he advised us of, Donald D. Simone, D, small d, little e, capital S-I-O-M-I-M-O-N-E, with his telephone number. We attempted to reach the attorney tonight. Did we call him again today?
No, I left a voicemail, both my cell phone and yours.
We have not heard back from them.
Oh my God!
That can move forward once somebody advised us they've got counsel and they're invoking their Fifth Amendment privilege. As a consequence, we will not be offering the witness, but we wanted the record to adequately reflect what I think shows good faith. First, I have what's been marked as Defendant's Exhibit 13R, which is an excerpt which I provided to counsel sometime earlier today, I think, maybe an hour. And I had made a statement to the court with respect to the alleged child pornography, and I said it was on a cell phone, and I was corrected. I knew I saw it someplace. It is in the recording, and I would tender and ask that it be admitted for the record purposes only, 13R, Your Honor, in which the witness, potential witness, Mr. Horace, tells our investigator that
Counsel, with regards to that, because the court is aware that there are certain connotations with regards to any offense of that nature. If you just want to admit it into the record, it's in the record.
all right. I wanted the court to know that I was making a good faith
Yes, I
statement
appreciate
about
that.
what I saw.
All right.
So I was mistaken on two counts. One, when I said that I was in error when I said it. Now I withdraw that and want to show the court why I said it. Secondly, Your Honor, I would offer Defendant's Exhibit number 14R. And it is, Your Honor, it is the excerpt that show the basis for the specific questions that Mr. Hunter asked of the witness, Joanna Reyes, the state witness. And it's being offered for the purposes of demonstrating that he had a good faith basis for asking those questions. We anticipating that we would have the witness, which we do not. We're not asking this to be presented to the jury, but I think it is important that the court knew that we didn't make that up out of the whole cloth here.
Okay, so I will tell both parties, in looking at 13R, so they're saying that pictures were found inside the camera. Were there pictures found inside of the camera?
No. In fact, the camera was never recovered.
Well, by the way,
and so-
It says cell phone,
All right, so.
and that's what I said.
All right, so with regards to defense 13R, nothing was ever taken from the cell phone. So
That's correct.
so it appears that if somebody was saying that there was something in a cell phone, I don't know if that was interrogation techniques or what, but do both parties agree that there was nothing, no photos pulled from the
We have
complainants?
no idea, it was never done.
No, there's no evidence of that, Your Honor.
There is no evidence because nobody was able to look. Now, it's offered not for the purpose of the truth of the matter, but to show why able counsel asked those questions, because we expected that witness to say that that's what she said, which was contrary to her testimony.
Well, and
Yes.
I can understand that, because I listened to the recording, and what is alleged is that the state told the witness that illicit material was found, which is fully untrue. So that's not really.
We're not offering it for the truth.
All right.
We're just offering it to show the good faith basis for the question.
Okay, so this is,
So you got two, y'all had
we're gonna have one person at a
I'm
time.
sorry.
I'm listening to
had
everything.
y'all to speak.
So, I have some questions, and then we can talk about defense's exhibits. Are there any other exhibits, defense?
Yes, Your Honor, there is, I believe it's 14 R which is the basis for Mr. Hunter's question, if you're still speaking about the photographs on the cell phone, which is, I think, what counsel was alluding to.
Okay, so, the only evidence that you're offering in for the record is 12R, 13R, 14R, and what is the?
11.
And 11R, is that correct?
11R is the total recording arm, which
Okay.
has been provided to the state.
All right, so anything else that's being offered into evidence for the record?
Yes, Your Honor. The basis for Mr. Hunter's question.
No, I mean, do you have any other exhibits to be offered into the record?
No.
All right, so, oh, and counsel, you can remain seated. It makes it easy for the court reporter to hear. So I want to take these matters one at a time. All right, with regard to this witness, Mr. Horace, was he subpoenaed?
No, Your Honor, we didn't learn about him until he called Mr. Hunter night before last, emailed him, and Mr. Hunter appropriately said, I can't speak to you. I'd like you to speak to our investigator. And that's when the conversation the next day happened between Miss Joanna Collins and the witness.
All right, and I'm
The
assuming
potential.
that the email contained information that you thought would be relevant to this case?
No, the email that we're talking about, that he said I'm retained counsel.
Your Honor, just to clarify,
Yes.
the email contained a photograph of Mr. Horace with Ms. Reyes, which was tendered to the witness as defendant's 10. And we asked the witness to identify the individuals depicted in the photograph, and I believe the witness testifies that that was her ex-boyfriend and her. And he indicated that he had information about the case, and that's why we directed him to our
And-
investigation.
All right,
And I
and so
should-
what date was this? That
The day
he,
before yesterday, right?
so we're saying this was Tuesday?
The initial contact was made on the 8th.
Okay.
And understand that we're not offering this to put it into evidence. We're offering it to show the good faith nature of his question.
So, all right, so I understand that. So then you all had no intention of calling him as a witness?
We
Well,
did.
but we would love to, but he has advised us that he's invoking his Fifth
So,
Amendment privilege.
well,
And
this
what
is-
I'm advising the court is that we're gonna honor that. And since we can't contact him directly, unless the court wants to continue this case. And
No, let's call the attorney. It appears,
We've been trying, Your Honor, if the court wants to try.
all right, just give me a moment.
So,
And I'm assuming it's this law office that handles civil cases? Are they in Houston?
that was our understanding before. However, he advised Ms. Collins last night, late afternoon, that he had retained her during and he wasn't there.
Hi, this is Judge Boyd. I'm the judge here in Bexar County, Texas. I'm trying to get in touch with Donald D. Simone. Thank you. Hi, this is Judge Boyd in Bear County, Texas. I'm trying to get in touch with Attorney Donald D. Simone. Do you have a cell number for him? All right, do you know how long that will take? All right. Can I leave my number with you, and if you could have him call me as soon as possible, please? That we will start at 2. That will give us some more time to make sure everyone has what they need. So,
This relates to the question, other than
exactly their time announcements. If they say it's going to be an hour, it's an hour, it's not more. So, with regards to the defense exhibits, I don't know if y'all want to wait and come back at 1:30. I'm telling the jury to be back at 2. So at 1:30 we can see what the results of are with the attorney and with your potential witness.
That's fine, Your Honor, and we'll be I'm not gonna go anywhere, so I will be here in case they call back. We can do what the court suggested. I'll have my counsel. I would like to advise the court that when all this is over, so you have some idea where we're going. All we're offering it is to show that we made, that it was a good faith, those were good faith questions. I don't think that's gonna be an issue. The second thing is whether the state has the opportunity. This just relates to the questions other than the one with respect to the photo, to the questions that Mr. Hunter asked. I am asking the court to consider when this is all over with, if we don't have a witness, that the state not be allowed to argue or infer that we were somehow dilatory or not being honest in asking those questions and not having a good faith basis for them. If that's the case, I believe I'm being made a witness in this case, and I'm going to have to move to withdraw your.
All right, so what I can say is with regard to Defense Exhibit 13R, it appears that this is some sort of hearsay within hearsay, because it's saying that it's alleged that the witness is saying that a district attorney and a private investigator told her something. And it's not a statement it doesn't appear that it's a statement that she made.
That's with regard only to the photos, and that's not the issue. The issue is with respect to the questions that Mr. Hunter asked. The photos didn't come in, and the court admonished the jury at length, and as opposed to our instructions, she admonished them at length not to consider it. I just wanted to show that I had a reason to believe that I said it was on the phone. What we're talking about is the questions that Mr. Hunter asked, and we used his name because we thought he would be here, and I believe we're entitled to, since the witness denied it, and we don't have a witness to rebut it, all we were offering the statements for is her statements that are exactly contrary and mutually exclusive with what she testified on cross. And if all I'm saying is Mr. Hunter had a good faith reason to ask those questions, and we shouldn't be put in a position of, if we're doing it in good faith, making it look like we didn't make any efforts to produce the witness. We're availing ourselves of the able court's process. If we can get it, great, but otherwise I don't think we should be made to look like we didn't offer. There were witnesses that they said are out of the country they can't get, who are material. She was the head and senior CSI officer. Can we argue that they are responsible for her not appearing? I'm just saying that
I think legally you can argue that she didn't appear.
Okay, I understand that. I'm concerned that that it's going to look like us, and it deals with our credibility, that we misrepresented the fact that he said that. And since they're not going to be able to see that he did say that to us, I wanted to be sure the court knew we had a good faith reason for it. And I don't think that we should be punished for that. I think we followed the ethical rules, and I think it puts my credibility and Mr. Hunter's credibility and ethical consideration. We got the wife of a very well-known lawyer in this town on that jury. I don't want my credibility or my ethics to be put in effect. I think they've created a problem for me. All I'm saying is, as long as they don't say that, look, they asked those questions about this guy and he didn't show up. He's entitled. If he's going to invoke his Fifth Amendment privilege, let's have him invoke it before the jury.
And Your Honor, just very briefly, if I can add a little addendum to what Mr. Goldstein says, and this can be discussed more at the charge conference. What I think Mr. Goldstein is urging is that there would be limitations on what the prosecutor would be entitled to argue based upon that portion of Ms. Reyes' testimony, in the sense that there is a curative instruction that would be perfectly reasonable, that would apply to both sides, that can be given, which is to simply instruct the jury on the function and the purpose of Rule 613 in the charge, and to explain. You have heard statements in the course of this trial that are attributed to witnesses, some of which were adopted and agreed upon, and some of which were denied. You are to understand that any such statement is not being offered for its truth, but merely to confront the witness about whether or not they said it. And it is to be considered by you only in determining whether or not you find the witness credible.
I'm not putting that in a jury charge. Here's the thing. You all question witnesses. You all make your objections. I make a ruling on those objections. The jury, I don't believe, is thinking, oh my gosh, is the defense or is the state saying something that is untrue? The only thing they know is an objection was made and the court ruled on the objection. Either I sustained it or either I overruled it. I don't see how 613 comes to play in the jury charge, and I think we're moving far afield of defense's exhibit state.
I believe we're entitled, and I would re-urge now, and I will, if the witness testifies, we don't have to worry about it.
All right, let's cross that bridge when we get to it. Because
I'm happy to wait. I want to give the court notice, and I want counsel to know that if the witness is not going to testify, that we made our reasonable efforts and fulfilled our ethical obligations to our client, and I believe that puts my credibility in issue and John Hunter's credibility, and I'm going to move to withdraw. I'm not going to have that jury have the idea that somehow I'm engaged in chicanery.
It would be, what we're discussing, Your Honor, would be the issue of, while the prosecutor is well within their right to say that those statements were offered.
Okay, here's the thing. You all are talking about a jury charge. We're not at a jury charge state yet. The only thing we're at right now is, do you have any witnesses? It appears that you wanted a witness here. That witness is stating that they've retained an attorney. You all have tried to reach the attorney. You all have agreed that the court could reach out to the attorney. I'm telling you, the attorney is in depositions, started at 10 a.m. I'm being told that those depositions should probably last for close to an hour. I left them my cell number. They're going to zoom in. When they can zoom in, you all will have a chance to speak with them. But so both parties are aware, and this was an assistant, I'm assuming it's the assistant to the attorney, which it's hearsay, double hearsay, but she says they do not represent him in anything other than a civil matter. Has to do with an accident.
We didn't have a conversation
So,
with Mr. Hart.
Yeah. So that's all we're doing. We're not arguing the jury charge, what comes in, what stays out.
And the real question is whether he's doing it on advice. If it's not on advice of counsel, then I'm entitled to talk to him.
Well, we're going to find out.
And more importantly, Your Honor, regardless of that, I want to talk to him. But if he invokes his Fifth Amendment privilege, that ends my ability to deal with him unless the court wants to challenge whether he has that right. I'm happy if the court instructs me to, if he calls back and he invokes his Fifth Amendment privilege, to have him testify before the jury, question by question. And
No, what will end up happening, if you think he's going to invoke his Fifth Amendment rights on every question, then we can have a hearing outside the presence of the jury and see if that's the case. So other than this witness, maybe, are there any other witnesses?
It would depend on whether that witness testifies, but I can assure the court it would be short and that we're not going to have more than an hour and a half to maximum 2 hours of testimony, or at the max.
All right, then state your response.
Regarding defense exhibits 11 through 14R, I take issue with the fact, the good faith argument, okay, because the question that was asked by Mr. Hunter to the witness, Joanna Reyes, was, did you tell Mr. Horace that you personally observed child pornography on the camera?
That's not the one that we're
Well, no.
talking about.
That's what I'm talking about.
All right, so both parties. I will allow both sides to put what they want to put in the record. So once the state's finished, then defense, if you have some response, you can respond. State wants the defense response. If you have some response, then you can respond. So state.
The witness denied that because the witness never told that to Mr. Horace, and
Well-
she in fact did, let me finish. In the recording that was provided to me by defense counsel, Mr. Horace explicitly states that Ms. Reyes told him that the state told her that they looked in the phone and there was some examination on a cell phone and that there was child pornography. That is absolutely not true. The phone was never examined and there is no evidence at all of the child pornography. And so at the time, it's untimely now, but it was improper impeachment by Mr. Hunter that I couldn't object to because I was just provided this recording this morning. And so that's what I would like the record to reflect.
If I may respond to that, Your Honor, since that issue is directly pertaining to my question. As Mr. Goldstein explained, we did not have the benefit of the recording when the questioning was done. I had the benefit only of rough notes from the investigator. Secondly, I think that the prosecutor's argument misapprehends the basis of Rule 613, and we've made that record as explicit as we can. And I understand that there's disagreement, but we stand on our papers.
That it's not offered for the truth, Your Honor. It simply was offered to show a prior inconsistent statement, and that all I'm interested in,
Well, no, because from what I'm reading
yes,
is that according to the video that you all have given the state access to,
it's
and
an
that's
audio,
been
Your Honor.
and that's audio.
It's an audio.
All right, the audio and that what's been admitted for purposes of the record. I guess it's D11R.
It's D11R.
All right, so in it, according to what's been transcribed, the witness never said that she saw the illicit material. She's saying that a district attorney and a private investigator pulled her in a room and said, "This is what we saw."
Which we didn't have the recording
No,
at the
and
time so.
And I understand that, and what I'm telling you both is, I am not saying that either party has done something untoward. I'm not saying
The state
that.
has. I mean, that's the implication of what
No, what
counsel
she's-
is saying, is that we have done something.
All right, so here's the thing. All of you all are attorneys. I don't think anyone is going to do a closing arguments and say these attorneys are unethical. It's not allowed. State, do you have any intention in your closing argument, and I don't want to go into great detail, of saying that these attorneys are unethical?
It's not allowed by rules of evidence, Your Honor, so I intend to comply with that.
So that would be a no. So I don't understand why we keep going about being unethical and whether or not a jury thinks we're unethical, because you all make objections, both sides. I make my rulings on those objections. The end.
Well, no, if an argument's going to be made that we failed to call the witness, then we're going to ask to reopen. And if we're not allowed to, I think it does imply that we did something in terms of not calling the witness, and if the witness insists on their Fifth Amendment privilege, I think that puts us in a bind, an ethical bind, and I'm simply not going to have this jury believe that I did something like that.
You're not the person who even asked the question. Your co-counsel. Is your co-counsel going to withdraw because the jury will think that he did something unethical? Because your co-counsel is the one who was cross-examining the witness about, what the witness may have said. So if someone is saying that they're going to fall on their sword and withdraw, then it wouldn't be you. You didn't ask the question.
Well, just like the prosecutors.
There are two issues at play. The first is that the implication of what able counsel for the state just remarked about is, I think, plainly an indication to the court of the plan to strike at the defendants over the shoulders of counsel. And secondly, the way in which this process is going forward is attempting to drive a wedge of conflict between the defendant and his counsel, which is an issue under Strickland versus Washington. And it is a problem that has deeper implications.
All right, so let me give you all the deepest implications in this case. You all ask questions. People make objections. I rule on those objections. And you all can accept my rulings or not. But what I am telling you is, one, I expect everybody to follow the rules of evidence. I expect everybody to follow the rules of professional conduct. And if you don't follow the rules of professional conduct or the rules of evidence, that's where I step in. Now, if somebody believes that there's a wedge between them and their client, then file a motion. We are not here at this juncture to talk about the charge and what will be in the charge and the arguments that people can and cannot make. If you all want something specifically, and this goes for the state or the defense, that somebody is not allowed to argue, then file a motion. That's what I can tell you. That's the way it should be done.
We will do so. Thank you.
Now, other than this witness who may or may not appear and may or may not be available, are there any other witnesses?
There is before the court, and I believe it's been marked as 14, Your Honor.
14R?
14R. D14R.
Yes.
It is that clip from an Instagram from a Miranda Hubbard. I will tell you that it was at it's YouTube, Your Honor. And I'm not sure of this. Can you tell that from this? Anyway, it is before the court. Counsel has a copy of it.
I don't have a copy of it. What is
Well,
it?
it's in that. I put it out for
Not yet. Which one?
it is marked.
It's marked, but you haven't given it to the judge.
I believe we have. Can we?
No, I only have 12,
It is
13, and 14.
Your Honor.
I'll read 15R.
No,
You gave it to the judge.
let me see. May I see 14R, Your Honor?
Sure.
Right, then this is 15R. Thank you.
And I'm sorry, let's go off the record for a moment.
Thank you for calling Simone Law Office. Sarah Espanol.
You know what's crazy? Shreveport hates Baby. Bad. Shreveport hates Baby. Shit, they booed. When Baby came out of 50 Cent shit, they booed his ass. Like, boo. Like, everybody make some noise for Baby. The niggas like, boo. Hey, funny. I wouldn't have nothing to do with Hurricane Chris, dude. Niggas don't give a fuck about Kane, dude. Right. Hey, funny. What's funny? This is Chris said, cameraman. Hey, Chris said, yeah, yeah. Better speak up, bitch. Bitch. Yeah, better be rude, bitch. Oh, you busy. Oh, you busy. You a busy phone. You are a busy phone, honey. That's what I'm gonna call you from now on. Busy phone, honey. Busy phone, honey. Hey, how was that dope though, Frank? How was that dope, Frank? Hey, Ronnie, you know somebody that do body work on cars? I seen what kinds of that. Hey, so what happened with him and Kyle? My car with him. Just wanted to do what? was gay. That way was gay. Hop on. Nigga said I just called the judge. Hold on, y'all. We'll be back at 1:30, y'all. Y'all lock the fuck in, man. If you in the chat, man, if you in the chat, make sure you like this video, man. We'll be back. We'll be back. That nigga said, who came in here?